You're back with In Session, and I'm Ryan Smith, and we are getting close to verdict time. Stephen Davis's manslaughter trial is in the jury's hands. And prosecutors say his dangerous driving contributed to the violent death of these 3 teenagers. Now, as for the defense, attorney Bob Vitale says the blame lies with James LaCourcier, who was driving the teens down Gratiot Avenue. Take a look.
What Officer McNair testified to was that neither vehicle touched each other, that Mr. Davis was traveling at such a speed that he nor Mr. LaCourcier was traveling at such a speed, such an excessive speed, that he nor Mr. Davis, nor I would assume anyone on the road, could appreciate that speed. He's testified that Mr. LaCourcier was traveling at a very, very, very minimum of 80 miles an hour. And his exact words on the stand was, "That's an extremely conservative estimate." And when I asked him, could he be traveling as much as 95 miles an hour? He said, yeah, that's absolute. I don't think he said absolutely, but he said, yeah, that's possible. And when I asked him, what he thinks happened, remember what his testimony was. He thinks Mr. Davis overcorrected. That it wasn't, he didn't say it was a purposeful act. He never said it was a purposeful act. He said what happened is, I don't think he appreciated the speed, got out of there, went, oh, I got to get out of here, tried to get over, and that's when Mr. Davis, or Mr. LaCourcier, lost control of his vehicle. Now, yes, his police report did say that speed and driver actions, those are contributing factors. But I wanted to know who was the proximate cause of this. I want to know who was the cause in fact. I want to know why this happened. So I asked him, who's more at fault, officer? And he testified, Mr. LaCourcier was more at fault.
Bob Vitale worked as a police officer for 17 years before becoming a defense attorney, and he says he wore the badge to help society and moved to defense law for the same reason. And Bob Vitale joins us right now from Chesterfield Township, Michigan. Bob, great to have you with us again.
Great to be here. Thank you for having me.
Okay, now, Bob, I just want to ask you right off the bat, just in terms of your closing, and then we'll get into a few things. What was the most important point that you wanted to put across to that jury? Because you had a lot going on in this case, a lot of different testimony. You had to get them focused on a few small things that could get them to see Stephen Davis, is he innocent?
Well, I think clearly the most important testimony in the trial was the testimony of Officer McNair. That's what I wanted to focus the jurors on, because Officer McNair is working on purely physical evidence, and eyewitnesses at times can be wrong. And Officer McNair was not a defense expert that was paid thousands of dollars to get up there and say that Mr. LaCourcier was wrong. He was the people's own expert that they presented in favor of their case. So I wanted to point the jury or bring the jury back to that, because I believed in a large part that that's the only truly credible testimony that the jury could rely on.
Okay, and I want to bring you back to that in a second, but right now I want to show you something. Bill Cataldo said that Davis was certainly at fault. That was his position, but that he admitted that they do share some blame in this. Take a listen to this.
How come everybody else in this scenario got out of the way except those two? Except Mr. LaCourcier and Mr. Davis. Everybody else saw what was happening. They slowed down. They got into a safety zone. Except those two. And if it wasn't for those two, there would have been no accident. It takes two to tangle. Or tango. And that's what they did. If Mr. Davis hadn't participated, there would have been no accident. If Mr. LaCourcier had backed off, there would be no accident. It's not who's more at fault. It's that they're both at fault for it. It took two to create a fatal crash.
Okay, so Bob, the it takes two to tango position seemed to me to be a very tough thing for you to overcome in your closing, because once you start lumping them both into being at fault, it becomes hard to get your client acquitted. How did you combat that?
Well, with all due respect, I disagree with Mr. Cataldo, and what I wanted to try to point out to the jury is that you can't just throw both of them into the mix. You can't take Mr. Davis and Mr. LaCourcier and say, well, it's both of their fault, so just convict and be done. because only Mr. Davis was on trial, so only his actions for the purposes of this trial should be focused on by the jury. So as far as two to tango, as I stated, I don't think my client was tangoing with anyone. I think that he made some rash actions in a very few seconds that resulted in the accident, but I don't think for a second that my client's actions were purposeful or grossly negligent.
Okay, and when you talk about grossly negligence and him being part of a factor of this, we heard Sonny Hostin talk about that as well. We heard you say at the very least this is negligence or acquittal. Was that a calculated risk you wanted to take with the jury? Because you've got a situation where you're trying to get your client off, but there's a lesser included offense here as well.
Absolutely. The lesser included offense was negligent homicide, which is a statutory maximum of 2 years. And that's exactly what I was trying to do. In the event that the jury was not going to acquit Mr. Davis, I had to give him an out to take the lesser offense so that we could negate the manslaughter conviction.
Okay, I have to ask you this. You know, Bill Cataldo has a very interesting style, especially for a prosecutor. And my colleague Vinnie Politan and I were talking about earlier. You're used to seeing a sort of more freewheeling type on the defense side, and you are much more staid in your position, giving your arguments. What did you think of your counterpart there?
Oh, look, Bill is an excellent lawyer. I've known Bill for some time, and Bill used to be a defense attorney. So I think a lot of his style he brings from many, many years as a defense attorney, when he was a very good and respected defense attorney. But as far as his style, I don't know that it's right for me to comment upon that. I think he's a good lawyer, and I think we just have differing styles.
Somehow I knew you were going to say that. But, okay, let's bring it back to Officer McNair, because you mentioned that you took the prosecution's witness and you really tried hard to sort of get him to talk about your position and your side. And you even got him to talk about who was at fault.
Correct.
Which was very interesting. You mentioned that was one of the most powerful points of your case. But at the same time, he was still saying one was more at fault than the other. That could be a bad sign for your client, but that was a good answer for you.
Yes, absolutely. What I wanted basically the jury to see in Officer McNair's testimony was that if Mr. LaCourcier was more at fault, and I think there was no questions that Mr. LaCourcier's actions were grossly negligent, that the jury would quantify it and say, well, if he was more at fault than Mr. Davis, then maybe Mr. Davis was just guilty of ordinary negligence, again, which would negate the manslaughter charge.
Okay, and Bob, we got a quick second here. I just want to ask you one other question.
Go ahead.
How important was it that we did not hear Stephen Davis's statements in this trial?
Oh, I think that was extremely important. I think the two linchpins to this case were, one, suppression of those statements, because had they come in, I think we would have had a very, very difficult time with those, and two, Officer McNair's testimony. But those are the two keys, I think, to this case.
All right, Bob Vitale, you did an excellent job in that courtroom. Great to have you with us.
Thank you. Thank you for great being here.
All right, the accident.